Welcome back, ladies and gentlemen. We hope you had a scrumptious lunch. I am aware that we are a little bit behind agenda for today, but before we continue to the next session, we'd just like to request that you take a couple of minutes to complete the conference evaluation, which I'm sure you would have found at your seat. Kindly drop off the completed form at the basket located at the exit door or at the registration table outside. Patents, copyright, broadcasting, trademark. How do all these apply to people like Nicole David, Rafael Nadal, or Cristiano Ronaldo? Let's hear from Mr. Foong Cheng Leong, who will tell us more about intellectual property and sports. Please give a big round of applause to Mr. Foong Cheng Leong.
Good afternoon. Today I want to talk about image rights and trademarks and rights to use the name, image on the internet. Of course, this is all basically about a sports person's right in respect of intellectual property. There are of course other areas of intellectual property in sports law, especially when we're dealing with association, we're dealing with football clubs and all sorts of other clubs. So if you're looking at a football club, you always have this problem of counterfeit jerseys in the market, and then what do you do if you have counterfeit jerseys in the market? So in usual cases, you usually file a complaint with the Ministry of Domestic Trade, who will then go and raid the place for all these counterfeit products. So in respect of association, then recently we have, as mentioned by Justice Ma just now, the recent case that he had decided Kusuma Sport against Madisuka Negara. That was in respect of the design of a jersey. So that is also interesting as well. I've done one case also regarding sports association where the dispute was about software. So there basically was a software to calculate golf handicaps, and there was a dispute as to who owned it and the design, who copied who. So on basically that. By respect of sportsmen in general, there are three things we are looking at. There's one thing we're looking here. The first thing we're looking here is called the personality right. Something very new, not very new, but it's not discussed well in all around the world. In the UK, it is very popular. If you're a famous footballer, then you should have the right to control who uses your image to endorse any other products. So what is image rights? There is no exact definition that I could find in cases, but this case that I found, this quote here, for the benefit of the members behind, it says that image right means the right for any commercial or promotional purpose to use the player's name. Here in the case is a Wayne Rooney's case actually. So what happened in this case is that he assigned, and this is very peculiar, basically Wayne Rooney assigned all his image rights to a company that he owns called Stony 48. Later we'll see the name later. His wife also owns a company who also controls the image right, her image rights. So if you're looking at other footballers like people like Gareth Bale, he also has one company which also deals with his image rights. So basically, if you want to use his image for a certain product, to endorse his products, you should go to his company and his company will sign an agreement with you. So in this present case, what is image right has been defined in this agreement, and it includes, and it is not only image, a person's image, it also includes things like a nickname, slogan, signature, image, likeness, the voice, logo, get up, the initials, team or squad number. Last time we had Beckham 7. And then we have a reputation, video of film portrayal, biographical information, graphical representation. This is interesting because if you look at games like FIFA, they use the image of the footballers. That seems to be covered. Electronic animation, animated or computer-generated representations. So it could be a cartoon, sometimes it could be any form of representation of a person, that would fall under image rights. But the question here is whether image rights is an enforceable right in UK or even in Malaysia. So if, let's say, the usual problem, what happens is a company would take a person's image, let's say generally a celebrity or a sports person, for example, let's say they take Nico David's image and uses her name or her picture to endorse the product. So for example, a tennis, a squash racket, and this company uses her image, say this is endorsed by Nico David. So the question here is, could Nico David go and sue that company for the compensation? For example, here it would be the licensing fee, the endorsement fee to use her image for that product. So in UK, there's one case called Eddie Irvine against TalkSport. Eddie Irvine was a F1 driver. What happened is TalkSport took his image. He was holding a certain thing on his hand, and then they replaced the image. Sorry, that thing on the hand with handphone. So basically, they used his image for that advertisement, and Eddie Irvine sued. And it was decided that Eddie Irvine could succeed in this case in a passing off case, and I think they had to pay about 25,000 ringgit of licensing fee. So, but in the recent case, one thing about cases like this is for when we talk about sports personality in respect of image rights, that sport personality must attain certain level of celebrity status. So you can't be let's say, a very junior sports person with never won any medals before, never appeared in any newspaper, your name is unknown, and you can't, basically, it's very difficult for you to claim you have an image right there. But unless you are like people like Nico David or Lee Chong Wei, Gareth Bale, Wayne Rooney, so on and so forth, these people had attained a global celebrity status, and their names and their image is very useful when it comes to endorsing products. So why is endorsement of products necessary? Because when, let's say for example, when you see Lee Chong Wei's face, what can you think of? So if you are familiar with the space, the advertising space, is that when you think of Lee Chong Wei, you will always think of Samsung. Because Samsung sponsors Lee Chong Wei quite a bit. So of course, then you have also soft drinks as well. So all sports related products, you go to, who uses Lee Chong Wei, let's say you think of Lee Chong Wei, you think of that product. That is the power of association of these celebrities. In respect of this case, this is actually Rihanna against Topshop. So basically, Topshop used Rihanna's image on a shirt, and Rihanna went to sue Topshop for passing off. And in the judgment, the court actually said that this is not an image rights case. There is no freestanding general right by a famous person or anyone else to control the reproduction of their image in England. So likewise in Malaysia, we had a couple of years back, we have this case called Ultra Dimension against Lee Kwok Yoon or something like that. Basically, the Ultra Dimension used the image, captured the image of a lady with a group of children, and that image was used in advertisement. So for that, she went to sue for invasion of privacy. So unfortunately, in that case, she did not succeed because at that time, there was a dispute whether, it wasn't clear whether there's a right to privacy in Malaysia and invasion of privacy in Malaysia. And the court held, the Faizal Pambi Chik's decision says that there is no invasion of privacy rights in Malaysia, no recognizable invasion of privacy rights in Malaysia. But that has changed. Recent case of Masinda's case, Masinda against Ishaq, and then we have few other, No Shrina's case, a few other high court decisions which recognize there is invasion of privacy rights in Malaysia. That we will talk about later. But anyway, in Rihanna's case, it was passing off case. Actually, the one Eddie Irvine's case is also a passing off case. So basically, you have the sports celebrity or celebrity has to prove that he has goodwill in his image, goodwill in his name. There was misrepresentation as to the origin of the products, or whether he has given his endorsement of the product, and there must be damage, some form of damage or likelihood of damage. So in this case, their possible argument is that they lost the licensing fee that could be paid to them for use of the image. But what is the position in Malaysia? That is undeveloped in Malaysia. The past couple of years, we have 3 cases, all regarding one same party. This Gulati Exclusive Berhad, who had used images of a few local celebrities. So one of them is Zanita, another one is Tony Yusof, recently, and also Diana Johor, and another one is called Aja. Aja was successful in suing Gulati, and she was awarded 20,000 ringgit for the use of the image. Thereafter, Zanita and Tony Yusof and Diana Johor went to sue Gulatis for using their image. So what happened to the status of the case is unknown. This is all based on a newspaper report. There's no actual reported decision on this. In Tony Yusof and Diana Johor's case, they both sued for 50,000 ringgit each. So what is the status? As I mentioned, is unknown, but only thing that I could gather from the newspaper report is that Aja was successful in getting 20,000 ringgit. But again, it does not say whether it was an image rights case or even a passing off case. So that would be interesting if they had a judgment published on this. But then they have another case, the use of image of a celebrity. This was in Borneo. Shena Noor Elena against Kenwell. In this case, instead of suing for passing off, what happened in this case is that Shena Noor Abdullah is a celebrity, ex-beauty queen, if I'm not mistaken, and the company has used an image on a certain product. So Shena sued for 2 things: copyright infringement and 2, invasion of privacy rights. But she did not go for passing off. And I don't know why she did not go for passing off, but these are the 2 things that she went through. And in that case, the High Court held that one thing about copyright law is that the copyright subsists in the person who took effort in creating that material. So in this case, someone took a picture of Sherina, and that person who took the picture was actually the copyright owner of the image. So it's not because you're the picture you own the copyright. Someone who took the picture, that person owns the copyright. So if you really want to, if someone decides to use the picture, I think that one possible way is to get a deed of assignment signed between the creator, the person who took the photograph, and they sign it back to you for maybe $1, so that you own the copyright. So in the present case, she did not do that. She went to sue for copyright infringement anyway. The court did not allow the case because she is not the owner of the copyright. Secondly, of invasion of privacy rights, is that one thing is that the picture that was taken was not something private. So it was apparently taken from a Facebook page or somewhere on the internet. So in a way, is that if you want to protect your privacy, it must be something that you want to withhold first. So if you're looking at Chua Solec's case and Elizabeth Wong's case, both were secretly recorded doing something. And these are clear cases of invasion of privacy rights. But here, her picture was in the public domain, online, and basically there's no expectation of privacy there. So in this case, she had failed. But then the next question is whether the Personal Data Protection Act, the newly enforced Personal Data Protection Act on 15 November 2013, and came to force effectively on 15 February 2014, whether this would apply to, for example, someone has taken your image and put in advertisement. Would the Personal Data Protection Act apply? So one thing about Personal Data Protection Act PDPA, we call it for short, is that it applies only to commercial transactions. Anything of a commercial nature. So it is actually a very vaguely defined term, because I sit in the ad hoc committee for Personal Data Protection Act in the Bar Council. So one of the problems we face is what amounts to commercial transaction. When there's a direct link with 2 parties, yes, there's a commercial transaction. when there's an exchange of money or supply of goods involved. But let's say I do not know you, we have no relationship together, but I'm in the business. I take your personal data, I use it, thus the PDPA applies. So in the present case, if I take your image, I took a photograph of you on the street and I put in a newspaper or magazine, would the PDPA apply? So I think in respect of Malaysia's position, that is unknown. But in Hong Kong, I think there was a decision on that. I can't really remember whether what was the decision, but Hong Kong, it involves the photograph of a person on the street taken and put in on the newspaper. But one thing is that our position is very unique. Personal Data Protection Act, which applies to commercial transaction, and the other country that has commercial transaction limitation is Canada. Theirs is subject to commercial activity, whereas the rest of the world has no such limitation. So there will be an interesting test case when the commissioner of the Personal Data Protection Act would receive the complaint. And according to him, the newly appointed, not official commissioner, the department has done about 2 investigations, received about 50 complaints, something like that. But currently no one has been charged under the PDPA yet. So if, let's say, you can't go for you can't go for image rights or personality right, what can you go for? So trademarks is one possibility. But trademark, one thing is that it's only usually registered trademark is only in respect of the goods and services that you registered for. So for example, if you are a sports personality and you want to endorse badminton rackets, then you should file in a class for badminton rackets. So in respect of people like Beckham is a serial trademark filer. So he probably has about 200 trademarks around the world. Gareth Bale, he registered his mark in Europe, European Union, and Wayne Rooney also filed his trademark. And acronyms as well. One example is Cristiano Ronaldo 7, CR7. And the next one is a symbol. A few of the footballers have filed trademarks based on their, few trademarks on logos. So Gareth Bale is known to have registered this 11 of Hearts goal celebration. So if you watch English Premier League or you watch the Spanish League, when he scores a goal, he will do a heart sign with his hand. So, and of course, newspaper was crazy about frenzy because he filed a trademark based on that goal celebration. That does not mean that no one else can do the same signage when they score a goal. So this is only in respect when you file a trademark, you are only protected. You only can restrict people. You cannot restrict for the goods and services that you filed for. So if Gareth Bale has filed it for clothing, no one else can use this logo for clothing in the country that is registered. Anyone else still can use this goal celebration, the love sign, the heart sign, whenever they score a goal. Di Maria just did that. So it will be quite clear on the distinction between trademark and these signages on the live sports activities. So Lionel Messi also has one trademark like that. And what are the general things that they all filed for? So we're looking at, of course, very popular would be clothing, footwear, perfumes, somehow seem to be very popular, and accessories. So like necklaces, like armbands, so on and so forth, toys for kids, or even sporting equipments. Books, of course, when they want to write their biographies, magazines, bags, and entertainment services. So when we talk about entertainment services, they could be like top 10 goals scored by David Beckham. So people also filed trademarks for that. Beckham also filed trademarks for that, so that nobody can use his name in products when it comes to like CD or VCDs if they have filed for it. And countries, one thing about trademarks is that you need to designate the countries that you wish to protect your trademark. So you can't file one trademark application to cover the entire world. So there is something called a Metric Protocol application, which can cover potentially about a few hundred countries. But that one, you need to also choose the countries that you want to register your trademark. So in Southeast Asia, if you want to protect your trademark in whole Southeast Asia, you need to file it in each and every of the country. But whereas in Europe, you can always, European Union in particular, you can file one trademark to designate the entire European Union. You can, in Africa also, there is one French-speaking countries also where you can file one trademark to cover a few French-speaking African countries. So you need to designate the countries that you wish to register and what countries would be most suitable. Of course, the country of the origin. And in Malaysia, let's look at Malaysia.